Welcome to today's program titled Understanding the New MHPAEA Final Rules Could Be Good for Your Mental Health. All participants are in listen-only mode. You are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Diane Dygert. Diane, you may begin.
Thanks, Sadie, and welcome everyone. I have to start with a traditional legal disclaimer that this presentation has been prepared by Seyfarth for informational purposes only. It should not be construed as legal advice or legal opinion on any of your specific facts and circumstances, but instead it's for general information only. And you are urged to consult your favorite Seyfarth lawyer concerning your own situation and any specific questions you may have. So that out of the way, I want to say hello and introduce myself and my colleague, Ben Conley. We can't wait to talk to you about the MHPAEA final regs today, which we tend to pronounce MHPAEA, but reasonable minds can differ on whether you spell it out or pronounce it as an acronym. But I'm actually going to start out by handing it over to Ben, who's going to kick off the program for us. Next slide, Sadie. Thanks,
Diane. Yeah, so Diane said we're excited to talk about this. We certainly are, but I understand that many of you on the phone may be a bit sick of this topic because it is a law that has been around for almost 20 years now, a law that predates the Affordable Care Act, and one for which there has been drips and drabs of new regulations running now for that entire stretch. But here we are again because we do have some additional regulations. Unfortunately, for those of you who are hoping the end was in sight, we expect more. And in fact, we expect more within the next 12 months, maybe even the next 6 months. But one of the things that Diane and I consistently hear when we talk to companies about these rules are, these are very complicated. I need a plan of action. I need manageable next steps to understand what I need to do. And frankly, I need to understand the risk. So those are all things that we hope to arm you with during the discussion today as a takeaway so that you can have some very practical next steps. In fact, we have slides called Practical Next Steps that walk through exactly what you need to do. I will reiterate that every organization is a little bit different or farther along or farther behind in their journey, and that's fine. You do have a couple months to take some next steps. But this is one of the many laws in the compliance space where you're not too late until you're too late, right? So like we can't say, I mean, we can give you a compliance deadline, but there's some flexibility there that we'll talk about when we get to the compliance deadlines. But before we dig into what's new, we don't want to presume that anybody on the call has been with us every step of the way on this journey. In fact, I hope for your own mental health you have not been, but it's a great time to jump in because we can tell you the background and where we've been, and then we're going to talk about what's developed most recently. So if we can go to the next slide, what Diane and I wanted to do was start with an overview of where things stand today, dating all the way back to 2008 when this law originally passed. So Mental Health Parity Act passed originally in 2008 based on the premise or the idea that there was a perceived need to balance the scales in terms of what health plans were covering because Congress identified that many health plans provided robust coverage in the nature of medical surgical benefits, but not robust coverage vis-a-vis mental health or substance use disorder. So what Congress did with this law was not create a mandate, although we're going to talk about some recent developments that might start looking a little mandate-ish, but rather say, look, you can either be in or out in terms of coverage for mental health or substance use. But if you are in other words, if you are choosing to cover mental health benefits and substance use disorder benefits, we are going to create a baseline and require that you cover those benefits in a manner that is not more discriminatory than the manner in which you are covering medical and surgical benefits. So throughout the presentation today, you're going to see the M/S and M/S and MH/SUD. That's because that's what we're comparing here. We're always comparing the medical surgical benefits, which are your traditional health insurance benefits, to mental health and substance use disorders, and benchmarking them against each other. Now, again, it's not a mandate to cover these benefits, but if you do so, you must do so in a manner that imposes no more restrictive quantitative or non-quantitative treatment limits on those benefits. So if you cover them, here's the baseline is what you're covering in medical. You can make mental health substance use more generous than medical, but not less generous. Let's talk about what those tests mean, though, if we can go to the next slide. So inherent in the challenges of creating rules on how you create a benchline and compare the two is that mental health and substance use disorder benefits are different than medical surgical benefits. If I am feeling sad, I typically don't go to the doctor and get a colonoscopy. Maybe that's just me, but there is different types of treatment directed towards mental health substance use disorder benefits than towards medical surgical. Now, sometimes there's an overlap, right? Sometimes there's prescription drugs prescribed for medical conditions and mental health conditions, but often they're meaningfully different treatments. And in addition to that, medical guidelines recommend different approaches, even if the benefits are the same, right? So you can imagine why medical literature would say when you have a knee sprain, you need 5 physical therapy benefits, but when you are being treated for depression, it might be more of an ongoing course of treatment. And the first thing that Congress and the regulators tried to do in addressing this disconnect in this comparison of an apple versus an orange is to try and slot benefits into similarly situated buckets. So if we can go to the next slide, we can talk a little bit about what that looks like. So it's still a bit random in comparing these benefits, but the first thing the regulators attempted to do under this law is to say, when you're comparing mental health and substance use benefits to medical surgical, you only have to make that comparison across the same classification or what we refer to as bucket, right? So prescription drug coverage is wildly different than inpatient in-network coverage, so we don't want to compare across those two buckets. Instead, we will permit you to slot everything into 6 different buckets and compare only mental health substance use against medical surgical in the same bucket. So the 6 buckets are on the screen: inpatient in-network, inpatient out-network, outpatient in-network, outpatient out-of-network, emergency services, and prescription drug coverage. There's a little bit of nuance here in that in the inpatient and outpatient sections, there are some permitted subclassifications that we're not going to get into here. But by and large, those are the classifications. So when you're doing your cross comparison, that's the bucket you are comparing against. Now, I think there's a common misconception that you're only comparing to the same quote unquote benefit, right? So like if you're talking about therapy, then you are comparing physical therapy to psychological counseling therapy. That may or may not be the case, but just because they're both therapy treatments doesn't mean they're necessarily in the same bucket. You would cut across the actual treatment itself and look oftentimes to the setting and the network setting to determine whether those two benefits are being offered in parity. If we can go to the next slide. So the first thing we want to talk about is the quantitative treatment limits. Now, hopefully folks have some familiarity with this because this is frankly the original area where the regulators wrote rules. These rules have been around for a very long time, have been in effect for a very long time, and frankly are sort of, although not entirely, the most straightforward of all the guidelines under this law. And what these rules generally say is when you're looking at each bucket, you have to compare the quantitative treatment limits as applied to medical surgical against the quantitative limits as applied to mental health substance use disorder. When we talk about quantitative limits, we're talking about numbers written in your plan document, right? So deductibles, copays, coinsurance, visit limits, days of coverage, waiting periods, etc. anything that kind of has a number associated with it is something you would reasonably classify as a quantitative limit, and that would be the comparison that you're looking at there. And the requirement throughout the law is that you can certainly be more generous with respect to mental health or substance use disorder. You just can't be less generous with respect to mental health or substance use disorder. Now, that sounds straightforward because I've got, 30 visit limits on medical surgical, so I should be able to have 30 visit limits on mental health substance use disorder. It's a little bit more complicated than that if we can go to the next slide. So it's not sort of a separate and equal type test. So for instance, if you have 30 visit limits for physical therapy, that doesn't necessarily mean you can have 30 visit limits for mental health or substance use disorder. The reason why is the regulators don't want you cherry picking one restrictive limit in any given bucket for medical surgical and say, well, we found one. We found a very low limit on medical surgical. That should work then. We can apply that across the board to mental health substance use disorder. Instead, they are requiring that you identify what we would call as prevalent or predominant limits within the medical surgical bucket that you are in, and then limit your mental health substance use limits to something that is no more restrictive than those. So this is really a two-part test. The first step is looking at the type of limit, and that could be something like a copay or a coinsurance or a deductible, and asking whether that type of limit applies to substantially all medical surgical benefits, which for these purposes is defined as 2/3. So if you have a copay, you cannot impose that copay on mental health substance use disorder unless it applies to at least 2/3 of your medical surgical benefits. Then we know the copays vary, right? So the second step of the test is, okay, we've determined that we have a copay on substantially all medical surgical benefits, but we have 10 different copay levels. So the follow-up test is what is the predominant copay that applies in that bucket? So it applies to more than 50% of the medical surgical in that bucket. And only after you have satisfied both of those tests are you permitted to impose a similar limit on a mental health substance use disorder. Now, the regulator's perspective has always been, as long as you are being at least as generous for mental health substance use disorder, that's all right to be more generous for mental health substance use disorder. That said, we've started to see this sort of weird circumstance where plans are forced to make their benefits for mental health and substance use work due to the technical nature of this test. The DOL will repeatedly call this a math test, and well, I'm not good at math. My understanding is generally in math, there's sort of a right and a wrong answer, right? And so, for instance, typically in the health plan setting, if you were to be asked, would you rather have a coinsurance or a copayment? Which one would you rather have? And let's call it a big coinsurance and a low copayment just to make the comparison even easier, right? Would you rather have a $5 copayment when you go to the doctor or a 30% coinsurance when you go to the doctor? $100 bill, let's say, just to make the math easy for those non-math people on the phone. Obviously, you'd rather have the $5 copayment because that's $5 as compared to $30 in the coinsurance example. So you might think, if that's the two options for a mental health substance use benefit, and you're allowed to have a coinsurance, right, under the substantially all and predominant test, we've determined we're allowed to have a coinsurance, and the coinsurance we're allowed to have is 30% for mental health substance use, right? But we don't want our participants to have to pay that much for mental health and substance use disorders because we're generous plan sponsors. As I know, many of the folks I'm not even joking, many of the folks on the plan on the call are, people are trying to get good mental health benefits to their employee population because it helps for a variety of reasons. You may say, well, I don't want to impose that 30% coinsurance. That's a lot of money for people to pay for their kid to go to the psychiatrist or whatever the case might be. We'd rather have a $5 copay. That's better, cheaper, no longer a disincentive. We want to do the $5 copay. So I put this question to the Department of Labor just last week, and I said, well, look, it's a type of limit, a copay, that in our hypothetical does not apply to substantially all medical surgical benefits in that bucket. The predominant benefit and the substantially all test says you can have a coinsurance, but nothing on medical surgical as a copay. If it's better for participants, can we still do that? Can we still impose that copay because it's a lower out-of-pocket cost level? And the Department of Labor's response to me was, sorry, it is a math test. Math tests have right and wrong answers. And in this hypothetical, the copay is the wrong answer because it does not apply to substantially all benefits. So again, one of the many odd results we're going to talk about today that kind of may lead you to the conclusion that the law in some respects can be harmful from the perspective of mental health substance use disorder benefits. But again, DOL's perspective is this is a math test. There's a right and wrong answer. Run the numbers and adhere to those numbers. One final important point here. What the Department of Labor was going to do was proposing to add this test to non-quantitative treatment limits. So things like prior authorization requirements, which we're going to talk about more in a moment. The final regulations decided not to go that route, which I think was a good development for all. So positive step there in a sea of otherwise challenging news, I think, that we're bringing to the call today. Let me kick it to the next slide and give it over to Diane, who's going to talk about the flip side of the coin and where all the regulations have been recently.
Yeah, thanks, Ben. The anecdote you relayed on the Department of Labor not allowing us to give a better result to our participants is fascinating, and I wonder if it's more of a, well, we hadn't really thought about that before, so maybe we'll get some relief later on in our next 3 iterations of the regulations. So moving to non-quantitative treatment limitations. So these, as Ben mentioned, this is not a math test on this side. It is non-quantitative. So it's a treatment limitation in your plan that does not have a number associated with it. So kind of on the bottom half of the slide, we kind of listed a few examples, not a finite list. There's multiple examples of non-quantitative treatment limitations out there, but there are things like pre-authorization requirements. Do you require someone to get treatment pre-authorized more on the mental health substance abuse side than you do on the medical surgical side? Are there network access requirements to access the network, or are there referral requirements to even go to a specialist that exist more on one side than the other? Formularies. Sometimes people are surprised to think about this. Remember, one of our buckets was prescription drug coverage. So how your formulary works with drugs that are predominantly used in mental health versus medical surgical may be a non-quantitative treatment limitation. Provider reimbursement rates, how your medical necessity criteria is applied, comparing these two kinds of benefits, and et cetera. So all different kinds of non-quantitative treatment limitations. And as we were saying, just like on the quantitative treatment limitation, but without the math part of it, when designing your group health plan, you can't design your plan in a way that imposes these types of non-quantitative treatment limitations more restrictively to your mental health substance abuse benefits, treatments for those types of medical issues, than you do to your medical surgical benefits in those same buckets. So we're still looking at those 6 buckets and that visual we gave you earlier on the non-quantitative as we do on the quantitative. So if we move to the next slide, looking back a few years, so while the quantitative treatment limitation part of the mental health law has been around for decades, as Ben said, the non-quantitative is a little newer, but still been around for several years. The Consolidated Appropriations Act was passed really in the height of the pandemic, which mandated that plans do testing on their non-quantitative treatment limitations. And those testing results can be requested by the Department of Labor for review or by participants in your plan. We'll kind of talk about that later as well, how those notice requirements have been solidified and expanded. And if a violation is found, so you do have, arguably, if you do have non-quantitative treatment limitations that are more restrictive for your mental health and substance use disorder benefits, then you have to correct that violation within 45 days. You'll have to notify your participants that the plan is not in compliance in this regard. And the Department of Labor publishes, kind of like a shame list, a publicly available report on non-compliance, and could even notify state regulators, so in the case that you have an insured plan, for example. And then there's potential for statutory penalties and maybe the most financially difficult penalty is claims reprocessing. So any claims that were denied based on a more restrictive in violation of the statute limitation for these mental health and substance use benefits. So if we can go to the next couple slides here, we're going to talk about, so what's required. If it's not a math test, then what do I do? Like, how do I prove to the regulators, how do I show in an analysis that in fact I'm not applying more restrictive limitations when I don't have numbers to fall back on? So we're kind of talk about this in the next couple slides here, like how you do that, because I think this is very difficult to kind of wrap your mind around and then to commit to the written word, like how you're going to demonstrate this in a comparative analysis. So, you know, the first step and kind of the first 2 points here is you have to identify what your non-quantitative treatment limitations are in your plan and which buckets they apply to with respect to each group of benefits. So your medical surgical and your mental health substance use benefits. So, so really just kind of grappling, getting your arms around, in fact, what your non-quantitative treatment limitations are across each bucket, across each type of benefit. And then once you've identified what they are, you know, identify any factors that the plan used in designing those treatment limitations, any evidentiary standards or processes about, you know, well, this strategy makes sense for this type of delivery of the benefit. Pre-authorization makes sense in this setting, or, you know, residential treatment standards make sense in this setting for medical surgical or mental health. So what kind of factors did you use when you were applying in the design, in the input of your design, and then the application of those benefits? What were your factors, evidentiary standards, strategies, processes? And if they vary then between those two types of benefits, med surgical or mental health substance use, why the variation between those two types of benefits across those factors? Next slide, please. And then when you're applying those factors and those variations in the actual administration of your plan, how do you do that? Who's the decision maker when applying? Because remember, it's non-quantitative, so it's a more subjective standard. So who's actually making those decisions? Are you using an expert? And if so, what are the qualifications of the expert when you're relying on them in setting those recommendations for what the benefits should trigger by? And then kind of point 7 is bring it all together. So, you know, write all that down, discuss why you applied those standards, what the relative stringency is, how it's applied, who makes those decisions. And the Department of Labor would really like to see citations to specific evidence that this is appropriate for this kind of treatment, for this type of mental health or medical surgical benefit, whatever it may be. And then, you know, you gotta date it, you gotta put the name of the person or people who were involved in creating the comparative analysis by name and by title. So people will be kind of feet to the fire, right, in that they were involved in putting that comparative analysis together. So next slide. One thing that the Consolidated Appropriations Act did is it said the Department of Labor is going to review these comparative analyses, and we're going to, Congress are going to insist the Department of Labor do this on an annual basis. So plans understand, you know, what's out there, where they're making progress towards creating these compliant comparative analyses and where they're falling short. The Department of Labor has issued, I think, 2 reports already. The last one is very dated, from 2023, which covers the period through July 22. They have said, the Department of Labor said, we want to get on an annual report basis where we're going to report on data from August 1 to the next July 31st. And we're going to do that. We're working hard to get the next report out. We're going to get it out as soon as we can. But obviously, if the last report is through July of 2022, they're quite far behind in issuing that. And when they do issue the next report, it's going to be on the current requirements, not the brand new ones, which we're going to turn to in the next portion of our presentation. But this slide just kind of finds, I mean, the spoiler alert is that the Department of Labor is not happy with the quality of the reports that they've received so far, and they've been pretty vocal about basically saying nobody has submitted a comparative analysis that we think passes muster, at least again up to this point in time that they last reviewed it. The left-hand side of the slide lists some common deficiencies that they found in their review. And again, keep in mind that this was new. Again, this is only the second report, so it was kind of new to plans putting together, and everyone's trying their best, but obviously not in the Department of Labor's mind up to what they were hoping that they would receive in these reports from plans. So, failure to actually document the comparative analysis before you designed it, just making conclusory assertions without any evidence as to why you think that is the way it is. So what's your source for this? What's your evidence for this? Lack of meaningfully comparing benefits across the buckets within the categories. Just, not having any adequate explanation, being very conclusory, very summary, kind of all these things on the left-hand side point to. Just not enough detail to identify what's going on with the plan and what's supporting the reasons for the variations in the various non-quantitative treatment limitations. And then on the right-hand side, kind of identifying those non-quantitative treatment limitations where they think they're more problematic, maybe that they, identified in these first reports as being a source of problems. And these are requirements for pre-authorization or pre-certification. Difference is in the network provider admission standards. So, are you requiring different standards for your network providers and your mental health substance use disorder type of providers than you are for your medical surgical? Concurrent care review, making people come back and constantly kind of reauthorize a course of treatment, finding that exists more in the mental health substance use than it does in medical surgical. Out-of-network reimbursement rates, treatment plan requirements, kind of like that concurrent care review thing, provider qualifications. You can kind of see the trend here on the problematic side. So again, we're very late on getting the next report from the Department of Labor, and when we do, it's going to just be on what the requirements are through the end of this year, and we'll talk about how those are going to change next year. So let's go on to the next slide and talk about what the latest updates are, what happened with these new final regs. And I'm going to hand it back to them now.
Yeah, thanks, Diane. So everything we just talked about was established law and regulatory guidance, or sub-regulatory guidance for that matter. But one of the things that we saw happen post Consolidated Appropriations Act was people clamoring for more information and more details, as well as just sort of a general befuddlement amongst plan sponsors, if you will, because it was a big, complicated analysis. And in those congressional reports that Diane was talking about, we were consistently seeing the Department of Labor only identify deficiencies and never conclude that they had a final, comprehensive, robust, compliant analysis. So in response to that, and in response to what I think the Department of Labor saw as deficiencies in those analyses, they decided to issue proposed and now final regulations, rounding out the guidance on how to perform your non-quantitative treatment limit comparative analysis predominantly. So we're going to talk about that. And it essentially breaks down into two steps. But before we do, one of the things that is always most overwhelming to me about this guidance or this law is all of the different tentacles, if you will, and how to keep them all straight. So what we wanted to do on this slide was just to kind of show you everything that's out there with respect to this law and when things go into effect. We'll have another slide on compliance dates, but we wanted to have a single comprehensive summary in one slide just so you can contextualize where we are. So at the beginning of the presentation, you recall we talked about the quantitative treatment limit analysis, the QTL analysis. That's the math test. That has been around and is in effect now. The second piece is, and the other half, frankly, is the non-quantitative treatment limit analysis, which is, believe it or not, even more complicated. That is also in effect now because the Consolidated Appropriations Act said it was required to be done, the comparative analysis, by 2021. Department of Labor's perspective was that that was actually always in effect, but many people would disagree with their characterization of whether it was in effect. But without regard, it's in effect now. But what the recent guidance has done is clarified that test, the non-quantitative treatment limit comparative analysis. And some of those new aspects are new and have a deferred effective date, right? So what it did was really break this down into two parts. We're going to talk about that in a moment. One part goes into effect kind of now with some clarifications effective in 2025. The second part goes into effect in 2026. Before we round out the presentation, we are going to talk about some other considerations, sort of practical considerations from a sort of immediate next step standpoint that you need to be aware of. Some of those, again, go into effect in 2025 and others go into effect in 2026. But let's dig in because we do want to talk about this new two-part test to determine whether you have any impermissible non-quantitative treatment limits. So historically, the Department of Labor's perspective in written regulatory form was, look, the outcomes don't matter, right? If there is a disparate outcome between mental health substance use disorders, let's say more claims denied for those benefits as compared to medical surgical, that's okay, as long as the way you set up the limits is in parity, right? No more restrictive limits on the setup stage. And if the outcome is skewed towards, in favor of medical surgical with vis-a-vis more approvals or et cetera, that's okay. They've definitively changed their position on that at this stage. They've now broken the non-quantitative treatment limit test into two parts. The first is called the design and application test, which looks at the design and application of the non-quantitative treatment limits within your plan. Just reiterating this point because Diane had a non-exhaustive list earlier in the slide deck, but that's things like prior authorization, medical necessity, network adequacy, provider reimbursement rates, fail first therapy, all of those types of things and more constitute non-quantitative treatment limits. So the first question is, how did you design those limits and apply them in the setup of your plan? What we would call the inputs, right? The inputs to your plan. The second part of the test, and the kind of new part, which is not effective until 2026, is a new outcome test. Now, recall that originally they were proposing the math test that we talked about earlier, the substantially all predominant test. Fortunately, they went away from that. But they are now more loosely asking that you measure the outcomes for mental health substance use disorder as compared to medical surgical and determine whether there is a difference or what they call a meaningful difference or material difference. Sorry. So we're going to talk about both of these tests, but just to be clear, the design and application test predominantly is effective 1/1/2025 or kind of now, but we're almost to 1/1/25 anyway. The outcome test is not effective until plan years on or after 1/1/26. So let's go to the next slide. And Diane, I think you're going to pick it back up here.
Yeah, I'll talk about the first part, the inputs part, because frankly it's easier. So I left the outputs part to Ben, being the generous partner I am. All right, so the inputs part, and this isn't new, but it's more, it's more what we thought we would see on the non-quantitative treatment limitation with a little more, definitions around it and clarity around what the Department of Labor is looking for. So they basically say you need to, when you're designing your plan and thinking about how, as part of that design, you're going to apply the non-quantitative treatment limitation, they want you to consider your processes and your strategies. They've created new definitions for these terms, which we really didn't have before, to give us a little more clarity on it. So, processes are any kind of actions or steps or procedures that a plan is going to use to apply the non-quantitative treatment limitation to the payment of the benefit for that, whatever that treatment is. So that would be, any prior authorization that is part of the process to access that benefit, any referral to that specialist that is going to be required. You know, if you ask your that a person have a general practitioner first before they can access a specialist, and they have to refer them up to that specialist. You know, how does that work across the buckets and across in comparison with medical, surgical versus mental substance use, the treatment plan standards, and how those are all administered, as, you know, examples of those processes. And then the strategies, so any practices, methods, kind of internal metrics that the plan considers, has considered when it's designing how those benefits are going to work. So any applicable standards of care, if we're relying on any external guidelines from external third parties or external organizations when we are deciding how to design the plan for those benefits, any clinical rationale between those types of benefits that are supporting our decision to apply that non-quantitative treatment limitation. So identify those on the front end is the request, really demand of plans when they're designing their plan. And these are, again, effective in a couple months, not totally different from what we've been doing or we're supposed to have been doing with our non-quantitative treatment limitations up to now, but now under these final regs, very clear this is how they're designing, or how they're telling us we have to analyze our design on the input side. So next slide, one more slide on this first part here. Yeah, so the evidentiary standards, so these are, again, these kind of clinical, empirical, statistical evidence that these treatment limitations, non-quantitative treatment limitations, are appropriate for these kind of benefits to justify the, you know, the difference. And we can rely, and we'll talk about later in the presentation, recommending you do rely as much as you can on your third-party administrator or your insurance carrier's data when it comes to designing this, because they are the people who probably based your plan design on to begin with. Very few of our clients on the self-funded side are creating a plan from scratch without any input of their TPA. Or again, if you're insured, your insurance carrier. So what they want you to make sure you don't do is rely on any standards or factors that could be discriminatory. So any quality measures or treatment outcomes that could be biased in their application or not objective. You know, what licensing or accreditation bureau issued these? Are they fair and objective? Are you reviewing more often claims for fraud on the mental health substance abuse side than you would on the medical surgical side? Because there might be some bias, arguably, in the underlying system as to how that was set up, which I think historically wasn't was true, that they were more often reviewed and maybe legitimately, but those kind of biases have to be identified and make sure we're not relying on it when designing the plan on the front end. These standards and discriminatory factors have to work their way into our analysis for plan years beginning on or after January 1, 2026. So it's a little more time for us to identify and kind of wash out of our design process, of the input process, any of these discriminatory factors or evidentiary standards that we might inadvertently have. So that's kind of the design and input side. Going to the next slide and turning it back over to Ben is the very new outcomes data issues that plans are going to have to grapple with.
Right. Thanks, Diane. And so the new part of this law, which is contrary to what the Department of Labor and the regulatory agencies have said historically, is now they want to look at outcomes too. It's not good enough to have parity in setup. Now you have to have some modicum of parity in result. It doesn't have to be identical, but you need to at least look at it and think about it. So that means that starting for plan years on or after 1/1/2026, plans will need to accumulate and analyze outcomes data. Now, outcomes data is undefined, and there likely will not be an exhaustive list. Department of Labor has said that they're going to come out with new guidance that clarifies what types of outcomes data they'll be looking at. But some of the things that they're talking about include, number and percentage of claims denied for, again, mental health substance use in the same bucket as medical surgical, turnaround times for prior authorization requests, network utilization, reimbursement rates, various sort of nuts and bolts results under your plan for people seeking mental health substance use versus medical surgical. Again, the next step.
I just want to be just clear and interject, because I had some clients concerned about this. When they're talking about outcomes data, they're not talking about did the treatment work for your participant in the plan. We're not talking about provider side outcome. We're really talking about plan design outcomes. So just calm people down on that.
Great point. Great point. So again, you're only comparing across the same bucket. You're not just you don't have to look at, for instance, gender affirming care, which the Department of Labor has confirmed as a mental health condition, and look at the denial rate specifically for gender affirming care. You would analyze gender affirming care within everything else in that bucket from a mental health substance use disorder standpoint. So likely they're outpatient, either in or out of network. And then you would look to determine whether there are material differences in the outcome. Again, a little bit math-ish of a test, right? Because it's not a hard and fast, is this percentage higher than this percentage, but rather, is there a material difference? Undefined. You'll have some leeway and flexibility seemingly in determining whether something is material or immaterial in that regard. If there is a material difference in outcome, you're not required to fix the problem such that there is no material difference, but you are required to take reasonable steps to address the differences. So again, whether the steps you take fix the problem is less important of a question as much as did you take steps. But again, this is going to be, as viewed by the Department of Labor, an ongoing process where you have to relook at this periodically. We'll talk about frequency in a couple moments. And if you take reasonable steps and it doesn't make a change, presumably the Department of Labor's view would be that you need to take then additional reasonable steps to continue to try to close those gaps. We don't know what reasonable steps are. Some of the examples given are sort of Pollyannish suggestions by the Department of Labor of just tell your TPA to raise the reimbursement rates for non-network providers, which again, we all know that plans don't control the reimbursement rates in the network, TPAs do, and insurance carriers do, but that was one of the suggestions afforded. Educate participants on resources, look at implementing a telehealth option for mental health or substance use disorder, streamlining credentialing, again, a bit Pollyannish in suggesting that employers control that as opposed to the TPAs and insurance carriers. But those were some of the suggestions provided by the Department of Labor. Those steps that you've taken, again, this is all going to become part of your comparative analysis, your written comparative analysis. Those steps that you have taken will be integrated into your comparative analysis so that if the Department of Labor says, hey, show us your outcomes data, show us what you identified as material differences, show us the reasonable steps that you took to try and remedy those differences. Again, the Department of Labor acknowledges that there's not enough guidance on this, so this is the guidance that we expect to come in probably the next 6 months because this is going to be required for plan years beginning on or after 1/1/2026. If we can go to the next slide. So sort of in a different category, because that's the test, right? You've got your quantitative treatment limit, and then you've got your non-quantitative treatment limit test, which breaks down to the inputs and the outputs. But in sort of a different category, one of the things the Department of Labor had always told us along the way was that if you provide coverage, you don't have, this is not a mandate. This law is not a mandate. We're not mandating you cover any mental health or substance use disorder conditions. But if you do choose to cover mental health or substance use disorder conditions, you have to cover those conditions in the same manner as you do treatments for those conditions in the same manner that you do for medical surgical services in the same bucket, again, using the classification or bucket terminology. What plans apparently started doing, according to the Department of Labor, is that they would say, great, okay, we are covering treatment for depression, so we know we have to provide treatments in the outpatient bucket, so we'll do 1 10-minute phone call through our EAP. Department of Labor thinks that even though that is adhering to this, the letter of the law, it is not adhering to the spirit of the law. So they went a little bit further in these final regulations and mandated that, again, if you're covering a mental health or substance use disorder condition, then you must cover at least one core treatment for that condition in every classification where you're covering medical and surgical. Now, that's every classification. That's probably all of them. The Department of Labor, in conversations we've had, have acknowledged that if it's not medically recommended that you provide prescription drug coverage for some mental health condition, they're not going to force you to do that. You can certainly defer to and rely on medical literature on that. But generally speaking, that's the standard that would apply in terms of what you now must cover. Two clarifications there. One is that they use the term core treatment to describe what you must provide vis-a-vis meaningful benefits. Core treatment does not necessarily mean one treatment. It could mean a slew of treatments, right? So if the core treatment for a particular condition would typically consist of, counseling plus prescription drug coverage, those two services in and of themselves constitute one core treatment. But if there are, in any given condition, multiple core treatments, the other thing they've clarified is you only have to provide one core treatment, not every core treatment. So it's not a mandate to cover everything, but it is a mandate to cover one set of core treatments or services for that particular condition. If we can go to the next slide. A few other clarifications that came out in the final regulations. First, one of the things that employers have been looking at for years was, well, we can define whether something's a mental health or a medical condition based on either federal guidelines, either ICD or DSM, or any applicable state guideline. State guidelines, there are famously 50 states, and those guidelines were kind of all across the board in terms of what they were classifying medical or mental health conditions as. Department of Labor didn't like that, so they cut that angle out and require that you instead classify something as medical, surgical versus mental health, substance or use solely based on federally recognized guidelines under the ICD or DSM, and under the current versions as identified by the Department of Labor, which again, they've got kind of a toggle for when new guidance comes out, how much longer you have to look at the differences and reclassify. Another important clarification in that vein, they have said that, we've seen things like breast augmentation surgery, right? Arguably a medical treatment, but you could be seeking breast augmentation surgery pursuant to a mastectomy, reconstructive surgery, or pursuant to gender affirming care. What the Department of Labor said in these regulations, and by the way, it's 3 agencies, I just keep referring to the Department of Labor here because that's most relevant in the ERISA context. But what they've said is whether a treatment is medical, surgical, or mental health substance use is based on the underlying condition. So if the condition is a mental health substance use, every treatment stemming from that condition is classified as a mental health or substance use without regard to whether you might otherwise think of that treatment as medical or surgical. Another kind of big development, which creates a little bit of urgency for plan sponsors, is a clarification in these regulations that they believe that the comparative analysis, so again, the design and application analysis, so the input and the outcomes analysis eventually, which is the output or the outcomes, is now a document under which the plan is established and operated. You may recognize that terminology if you're familiar with ERISA, because that's the standard for when participants can make a document request and what types of documents they can request. So under ERISA, participants can request plan document SPD 5500, and now your comparative analysis. And what we know from ERISA is that once you receive that request, you must produce it within 30 days. Otherwise, you are potentially at risk of a penalty of $110 per day. So that creates some urgency, right? Because a lot of people historically had kind of said, well, we need this if the Department of Labor asks, but we're likely not a target of the Department of Labor, so we're just going to wait and see how the law shakes out. Now, starting in 2025, this is a document that can be requested pursuant to just any random participant request. That's ERISA only, that piece. But for any plan, subject to the Public Health Service Act, ERISA, or otherwise, participants can also request the NQTL for any adverse benefit determination that relates to a mental health or substance use condition. So sort of multiple different angles for participants to get their hands on this. And certainly something we're expecting to see from the plaintiff's bar is that document requests will be accompanied by a request for the comparative analysis, which does, again, create an incredible amount of urgency because you don't necessarily need it by January 1st, 2025, but you might need it by January 30th, 2025 if those requests start rolling in, right? If we can go to the next slide. The final new thing is the fiduciary certification. This one's got the one that's got everybody stressed out. And specifically, this is a requirement for ERISA plans only, but the requirement is that the plan fiduciary, which is typically the named fiduciary, so typically the plan administrator, which could be a committee, it could be an HR representative, could be the company generically, but think about whether that makes sense in light of this and other developments in this space, that they certify that they have engaged in a prudent process to select a qualified service provider to perform and document the non-quantitative treatment comparative analysis, and that they are monitoring that service provider to make sure that they are adhering to these guidelines. So previously, the standard was proposed to be you have to certify compliance with mental health parity, which would be challenging for most humans, let alone most plan fiduciaries who often have many other things going on and aren't in the weeds on these things. So this more adheres to the traditional ERISA framework, which is if you don't have the expertise internally as a fiduciary to do the thing you're supposed to do, you can engage a third party to do that for you. We're going to talk a little bit about who that might look like in a minute, but I want to keep plowing ahead here to make sure we get through everything. Diane, I think this is back to you.
Yeah, next slide. And we put this up there because we kind of talked already about the effective noncompliance, but which that part hasn't changed that much. But if a plan is found to not be in compliance with the NQTL restrictions in your design or your outcome, then and a final determination is issued that you're non-compliant, the agencies, so Department of Labor and the other agencies could issue an order that prohibits the plan from imposing that non-compliant, non-quantitative treatment limitation and require that the plan demonstrate that they've remedied it, which again could mean reprocessing claims that were denied because of the application of that non-compliant NQTL. If that happens, the plan would have to provide notice of the non-compliance to participants, which we mentioned earlier. In the final regs, the agencies did provide model language. So unlike the fiduciary certification where we didn't have model language and we can kind of design a staged fiduciary certification, which we can talk about, there is model language provided for notice of noncompliance to participants. So they did provide us for with model language there. So kind of moving on to the next slide, the effective date. And we've been talking about this, but just to kind of give you a visual of how all this works together. As we've mentioned, as we sit here today, the quantitative treatment analysis is already in effect, that math test, and has been in effect for a while. And the NQTL comparative analysis requirement has been in effect since 2021. For the 2022 year. So that is in effect, but as we've also talked about, kind of no one has kind of met what the Department of Labor thinks should be reflected in that comparative analysis. So as we move into January of this coming year, so plan year starting after 1/1/25, what's new now is the fiduciary certification piece and our obligation to produce that NQTL comparative analysis in response to the document request that Ben was talking about for ERISA plans or to all health plans in the event of a claims decision denial that arguably is based on a non-quantitative treatment limitation restriction. And then next year, for plan years beginning after 1/1/26, on or after 1/1/26, the new things there that Ben was talking about kind of related to the outcome side of the house. So providing meaningful benefits, prohibiting discrimination, prohibiting the design of the plan based on discriminatory factors or evidentiary standards, and that outcome side, that relevant data evaluation and related changes that would flow through down into the NQTL comparative analysis. So we'll have to have a comparative analysis for 2025, and then an expanded comparative analysis for the NQTLs in 2026 that adds in the outcomes piece of it, the outcomes data piece of it.
Yeah, and so
that's just, go ahead, Ben.
I was going to say, in the interest of Sadie, Diana and I are going to start talking through the practical pointers, but do you want to go ahead to the CLE slide in case people have dropped, and then we'll come back to those in the hopes that people want to hear the practical pointers and hang out. So our CLE process, so we've applied for CLE for the lawyers on the line, as well as for HCRI and SHRM for those non-lawyers on the line. If you have a smartphone, I hope that many of you do, please scan the QR code here and it'll take you through a series of prompts to apply. For people seeking CLE, you'll fill out the prompts. For people seeking HCRI SHRM, it'll solicit your contact information and you'll be followed up with CLE@Seyfarth.com to complete that. You're going to need the code here, which is capital S 9967. Again, that's capital S 9967. And we'll leave this up for a moment while we talk about practical steps. So first and most important practical next step from Diane and I's perspective is engaging a qualified service provider, which is, again, this new fiduciary certification process says you either have to perform the analysis yourself, which few organizations are going to be able to do, or engage a qualified service provider. So I think one of the main questions there is, well, who is that? The Department of Labor made very clear that it's not a new high bar that they expect, certification from some accreditation agency. It can really just be anybody who has familiarity with the law and with sort of the medical judgment necessary to make these comparisons and analyze, medical standards, et cetera. So we think that the first best starting point there is going to be your medical TPA or insurance carrier. That's frankly, the entity that has designed all of these NQTLs, probably for their insured book of business. So that's a great starting point. And while I know there was a question about, well, these TPAs aren't responding to our request for changes and TPA's analyses may be faulty. What does the DOL want to see? I guess my thoughts there is that the service providers are, the TPAs are getting a lot better at preparing these comparative analyses, because what's happening is that they're submitting them. DOL is looking at them. The DOL is saying this is no good. The DOL is going back to the client, or even sometimes directly to the TPA and saying you need to change this. And so they're enhancing, they're getting better every day. They're also getting more willing to play ball every day. Department of Labor's very strong opinion is that these are co-fiduciaries and they have an obligation to help you in complying with these laws. The TPAs don't necessarily share that perspective yet, but they are becoming more willing to play ball in that regard. There certainly may be circumstances where there are gaps, and that may be where you need to engage a consultant to fill the gaps. I know one of the questions was, should that be lawyers? And if so, should they be listed in your comparative analysis? We as a group have gone back and forth on this, but frankly, lawyers, from our perspective, while we think they're the best and they're great at everything, they don't necessarily bring special skills to the table that would necessarily render lawyers better or cheaper at doing this analysis than other consultants. We as a firm have been sort of accumulating a list of service providers in this space outside of the TPA and insurance carrier space that do a decent job at various price points. We're not going to list those on the webinar here for fear of suggesting bias. But if you want to reach out to the Seyfarth attorney you work with, they can certainly plug you in and help round out those gaps. And that might be important if you aren't getting an analysis from your TPA. The one you're getting is clearly deficient, or you have a more complex plan design such that you've got different carved out benefits and you need to blend them all together. Second practical step here, and Diane, interject as needed.
Yeah.
Second practical step relates to educating the fiduciary and receiving the fiduciary certification. So again, legally required 1/1/2025. You don't file it anywhere, but what the DOL has said is that fiduciary certification is part of and must be integrated into your comparative analysis. And recall that participants can request that in 30 days. The Department of Labor can request that in 10 days. So you don't necessarily need it, but you might be on a 9-day deadline to produce that depending on the circumstances. This is, by the way, not for non-ERISA plans, only for ERISA plans, but it does apply to fully insured or self-funded ERISA plans. So if you have a fully insured group of 9 people, you still have an obligation to create this fiduciary certification. Now, if you're fully insured, you can likely more heavily rely on your carrier's analysis than if you're self-funded, but you might be able to in both circumstances. But what the Department of Labor has made clear is that they expect the fiduciaries to engage in the process of looking at these analyses, looking at the requirements, and then certifying. It's going to look different depending on your organization, but we think that for a lot of organizations with, a committee or the like, it might be a sort of a written resolutions type certification. Diane, do you want to talk about the next one?
Sure. And just to go back to what you said before, and I know we're at the top of the hour, so we're going to try to wrap this up quickly for folks who have to leave. But we are seeing like that the TPAs become moving from we don't have anything to do with your compliance and your comparative analysis to, well, you can have ours, do with it what you will, to you can have ours and we'll try to work with you to identify where yours is different than our insured book of business. And we're hoping as, more and more of you as plan sponsors and plan administrators out there are pushing the world of the consultants and the TPAs that we'll see even more, linking of arms towards compliance comparative analysis, because that's the way this effort is going.
Sorry, Diane. Two more important points on that, looking at our questions here. One is think about that when you're contracting, because it's a lot easier at the contracting stage to get leverage. So we're trying now to get contracts to say that the TPA agrees to be a qualified service provider. But even if not, that they're agreeing to give us all the data we need to do all of these things, right? And then the one question was, what if the TPA is not helpful? Department of Labor's, this is kind of weird, but the Department of Labor's perspective is if that's the case, send them our way or send us their way. You can lean on them. You've got an ongoing relationship there, but that's the Department of Labor's perspective on if they're not cooperating. We're seeing them be more accommodating here. But sorry, back to you.
Because of that statement, but not in large part because of that statement. Yeah.
Right.
They want to cooperate. So, this slide focused on the DOL identified priority issues that we were talking about in their report. Hopefully we'll get another report soon from them that kind of helps us focus in on where they think weaknesses are with these NQTLs. And here on the bottom of the slide, monitor legal developments. As of a couple days ago, we know a new administration is coming in, a different party with a different view on their approach to regulatory guidance in general. And we think we'll may be weighing in on what's happened here and, kind of layered on top of the Loper Bright type of challenges that we know no longer require that the courts necessarily give deference to agency pronouncements in these regulations. So that may also change the trajectory of what we're seeing with respect to the regulations in the mental health parity world. So with that, I think we are going to have to log off. You can go back to the QR code for a second, Sadie. I think a couple people might have asked for it again.
And I know we got a couple questions. We tried to hit some of the questions along the way, but we got a couple that we didn't get to, but we'll try and follow up with those folks directly.
Thanks, everyone.